Good morning, I'm Gary DeWaal, and this is Bridging the Week for July 22nd through 26th, and today is July 29th, 2019. A federal appellate court in California issued a decision ratifying the Commodity Futures Trading Commission's expansive view of its authority to bring enforcement actions addressing a diverse range of purported wrongdoings under the Dodd-Frank Wall Street Reform and Consumer Protection Act adopted provision prohibiting manipulative or deceptive devices or contrivances. In the same decision, the court also agreed with the CFTC that another Dodd-Frank adopted section that excludes from CFTC licensing requirements the sale of leverage or margin commodities to retail customers where actual delivery occurs within 28 days means real delivery to such persons or their agents without liens or other encumbrances. This interpretation may have a significant impact on virtual currency and other businesses that offer or seek to offer leverage or margin financial products from the United States or to U.S. persons. Summer continues its hot assault on many parts of the Northern Hemisphere, raising temperatures to 109 degrees Fahrenheit in Paris last week. So I can stay cool here in New York City, inside my apartment and office, and not worried about outside temperatures. Let's get started. A federal appeals court in California reversed the dismissal by a federal district court of the Commodity Futures Trading Commission's September 2017 lawsuit against Monex Credit Company and related companies and principals. Monex is a retail precious metals dealer based in Newport Beach, California. The CFTC had alleged that Monex enabled retail investors to purchase precious metals on margin without delivery through its proprietary Atlas program and not on a licensed exchange or board of trade as required by law, and committed fraud in connection with solicitation activities by making false or misleading statements. Monex prevailed in the district court motion to dismiss these charges. The district court rejected the CFTC's view that actual delivery as required by the relevant statute could not occur if retail customers who finance their precious metals purchases granted the seller a lien or encumbrance on their commodities beyond 28 days. The district court also held that the provisional law relied on by the CFTC, prohibiting, quote, any manipulative or deceptive device or contrivance, end of quote, required that the Commission allege fraud that affected or potentially affected a market or constituted fraud-based manipulation. Since the CFTC solely alleged that Monex engaged in fraud without reference to any market or manipulation, the agency's charges against it could not stand, ruled the district court. The United States Court of Appeals for the Ninth Circuit reversed the district court's appeal. First, the appeals court held that the district court misapplied the relevant law that exempts leverage or margin retail commodity transactions from CFTC oversight where, quote, actual delivery occurs within 28 days. End of quote. Monex claimed that this provision would have no practical meaning if, quote, actual delivery, end of quote, required possession of control by a customer, quote, because such a reading would clash with margin, which means cash or collateral required to be paid to a securities broker by an investor to protect the broker against losses from securities bought on credit, end of quote. However, the appeals court rejected this view, writing that, quote, while permitting customers to obtain significant control or possession of metals might be practically difficult here, that fact does not displace the statute's plain meaning, end of quote. Second, the Court of Appeals concluded that the word, quote-unquote, or in the phrase manipulative or deceptive device or contrivance must be read disjunctively and not conjunctively. As a result, the CFTC has authority to bring enforcement actions where it alleges either a manipulative device or deceptive device or contrivance. It need not charge both, said the appeals court. The Court of Appeals decision will surely embolden the CFTC to apply its Dodd-Frank given anti-fraud authority more broadly. It already has applied the relevant provision in a wide range of enforcement actions stemming from its first use in the J.P. Morgan London Whale episode to allegations of illegal off-exchange metals transaction, claims of more traditional manipulation of wheat, allegations of spoofing, and claims of insider trading. More recently, the CFTC brought and settled an enforcement action against the former portfolio manager for mismarking valuations of certain interest rate swaps from approximately June 2016 through April 2017 in order to increase his performance bonus relying on these provisions. Similarly, rejection by the Court of Appeals of the District Court's holding that the CFTC's view of actual delivery appears to undercut Congress's effort to accommodate leverage and finance commodity transactions in Dodd-Frank may also embolden the CFTC to prosecute more U.S.-based unlicensed trading platforms or dealers that offer persons anywhere leverage or margin commodities of any kind, including virtual currencies, and non-U.S. based persons that offer such leverage or margin products to U.S. persons. The decision could also jumpstart the CFTC's finalization of its 2017 proposed interpretation of actual delivery involving virtual currencies. I have more on this on the written version of the blog at www.bridgingtheweek.com. Check it out. The Securities and Exchange Commission's Division of Corporation Finance issued a no-action letter saying that a digital token designed to facilitate access to a multitude of online video games would not be required to be registered as an equity security. The no-action letter was sought by Pocketful of Quarters, Inc. for its proposed Quarters digital coin. Pocketful proposes to introduce a Quarters platform that will leverage blockchain technology to allow gamers to access participating video games and enter hosted tournaments to compete against one another using Quarters, which it hopes to evolve into a universal gaming token. Corp Fin said it granted no action to Pocketful because, among the reasons, the firm would not use funds from Quarters sales to develop the Quarters platform, Quarters would be immediately usable at the time they were sold, Quarters would be made available in unlimited quantities and fixed prices, and the purchase price of Quarters would correspond to the market price of accessing and performing on participating games. Additionally, Quarters would be marketed solely for consumptive use and as a means to access participating games and not as an investment. A few months ago, Corp Fin granted no-action relief to Turnkey Jet in connection with its proposed digital token, structured as a stablecoin, to be used on a private blockchain to pay for chartered air services. Although both the Turnkey and Quarters no-action letters provide valuable insight into what indicia Corp Fin believes would not cause an asset to be regarded as an investment contract and thus a security, the fact patterns hardly seem controversial. A stablecoin backed 100% by fiat currency and an emission token to arcade games do not seem the type of instruments that could reasonably be deemed securities. Although SEC staff should be applauded for taking small preliminary steps to not interfere with the development of legitimate blockchain technology applications, some bigger leaps are hopefully forthcoming. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a nice week, and until the next edition of Bridging the Week, stay cool and ciao.